Hi everyone, this is your friend Junga. I'm back with another video. Today we are going to discuss on a very cardinal topic, that is secular. I believe that as a concerned citizen of India, we need to know what is secular and how far it is applicable in our society. So secular, if we say secular, the term secular, it implies that the state has no particular religion. The state will perceive all religion equally, whether be it in terms of providing freedom or opportunities to distinct religion that prevails or practice in our country. India follows the ancient principle of Sarva Dharma Shambha, which means that the India where whatever the religion that practice in India will be perceived equally. All religions are equal in the eyes of the law. If we speak about the secular, the very term secular has been incorporated in the preamble of the Constitution according to the 42nd Constitutional Amendment Act in the year 1976. And after this, the question may come, since this the very term secular is incorporated in the preamble of the Constitution, so whether preamble of the Constitution is amendable or not. And if we see, then there were two case laws we will be repeating right now, because in the case law we see a Veruvari case of 1960. The Supreme Court upheld that since the preamble is not the part of the Constitution, so it cannot be amended. And later we found that the Supreme Court has first a historic verdict in the Keshavnand Bharati case in 1973. So the Supreme Court verdict held that since the very preamble is the part of the Constitution, so it can be amended, but it was a condition, it was subject to condition that whenever there is amendability of the preamble, so it should ensure that the basic features of Indian Constitution should not be at harmful stage. So it means that the basic features of Indian Constitution are ready or guarantees to provide secularism, social justice, etc. The term secular itself is the basic features of the Indian Constitution, so there should not be any apprehension that since it is the basic part of the Indian Constitution, so it will always be in a positive note and it will always be under the custody of the Indian Constitution. The Indian Constitution provides Article 368, which gives right to the parliamentarian to bring some necessary amendment of the Constitution if required. But at the same time, even after the enjoying the right of Article 378, the parliamentarian cannot harm the basic features of the Indian Constitution. So in this stage, we can say that we are safe with the verdict of the Supreme Court, as well as the since it is incorporated under the basic features of the Indian Constitution. Now the question may come whether this whether this secular, since it is incorporated in the preamble, whether it is it can be whether it is justiciable or not. But we must know the fact that directive principle of state policy is non-justiciable, and at the same time the term secular is also non-justiciable. Why? Because it is incorporated in the preamble. So now there can be a question, then how far this that very term is is in under safe zone. Then if we see, then we need to switch to the fact that the fundamental right of the Indian Constitution has guaranteed us right to freedom of religion, that is enshrined in the fundamental right article 25 to 28. The article 25 of the Indian Constitution class 1, it speaks about the freedom of religion, which incorporated freedom of conscience and right to profess, right to propagate, and right to practice. So according to the fundamental right freedom of religion under article 25 to 28, we have been guaranteed that we have the right to profess, right to have freedom of conscience, and we have right to propagate and right to practice. So it means that since the fundamental right of the Indian Constitution is justiciable in nature and it can be forced in the court of the law, so there cannot be any apprehension regarding the curtailment of this fundamental right, because the fundamental right itself speak about freedom of religion, and the freedom of religion itself deals with the very term secular, which is incorporated in the preamble of the constitution. And keeping it aside for a while, if we look into the article 15 of the Indian constitution, which speaks about the right to equality, the state shall not discriminate against citizen on the ground of religion, caste, sex, etc. So in this context also, if we look into the fundamental right of the article 15, which guarantees right to equality, the Indian people are safe, because whenever there is a violations, then we can knock to the door of court, and we can seek for our deliverance of justice, and the honorable Supreme Court along with the High Court, they will certainly provide us the justice to us. So in a nutshell, we can conclude that although we speak about vulnerable condition of secular, but it won't be take some sort of overnight decision, and which will scrap the very basic principles of the constitution. The secular cannot be scrapped overnightly. Thank you.